The next presentation is by Professor Stone, and she will be addressing us on. What do I do now? Okay. We'll be addressing us on the limits of constitutional evolution, separation of powers under the Australian Constitution.
Thank you. Oh, well, it's an honour to be on a panel about old constitutions. I have to say, I think of the Australian Constitution as being very old, but compared to the constitutional traditions represented to my left, I think it has a claim to middle age. It was, of course, superimposed over a society that I should respectfully acknowledge contained a very sophisticated system of Indigenous law prior to the Australian Constitution, and I have colleagues working in the area who will claim that those rise to the level of constitutional systems, and I should make clear that by not speaking about them today, I don't wish not to acknowledge the prior existence of the Indigenous people of Australia and their constitutional systems. But the Australian Constitution I'm talking about was designed over the 1890s and came into force in 1901. So it was designed to govern a British Dominion at the dawn of the 20th century, and it now, almost unchanged, it's not quite as difficult to change as the US Constitution, but it is very difficult to change. Almost unchanged, it now governs a large, complex, culturally diverse and fully independent nation state. Now, in these circumstances, constitutional evolution in all respects have been more than usually important. And in the case of separation of powers, we see the development of a weak but recently strengthening conception of the separation of executive power and a strong and highly particular conception of the separation of judicial power. And in this paper, I'll trace the development of this asymmetrical separation of powers doctrine, and I'll spend a little more time on the separation of judicial power, which enables me to make what I think are some especially important points. I want to show that the nature of Australian separation of powers is attributable to the particular constellation of features that characterise the Australian constitutional polity. And that is, we have a Westminster system of parliamentary governments transplanted in a system that also contains elements of a system of written constitutionalism, federal division of powers and judicial review. And the combination of the federal system with judicial review and a Westminster system has posed particular problems for executive power. Okay. The other major challenge posed by the Australian constitutional structure for separation of powers is, of course, the sparsity of rights protection in the Australian Constitution. Framed at the dawn of the 20th century, like all British dominions, it contained almost nothing by way of rights protection, and given its rigidity, not terribly much has changed since. So the challenge for Australian constitutionalism in general and separation of powers in particular has been to respond to these difficulties in the Australian situation. And I want to show that the development of separation of powers doctrine is partly an optimistic story about the capacity of courts to adapt constitutions in ways that respect rule of law and rights in rather inhospitable terrain. But I do want to sound a note of caution about recent developments in the separation of judicial power doctrine that I think show something interesting about what I would call the limits of the evolutionary capacity of separation of powers. Okay, so perhaps I should say just a little. I think I've said enough by way of background about the Australian Constitution. So let me turn first to the question of the separation of executive power under the Australian Constitution. So we are a parliamentary system with the executive drawn from the legislature. Like other Westminster systems, that's given rise to problems of executive dominance. They're compounded in Australia because we also have a system of a federal system. And the particular challenges for a system of responsible government in a federal system is that the executive dominance has not only upset the relationship between the executive and the legislature, but it's also led to a problem of a dominance of the federal executive. An Australian federation has been characterised by a high degree of vertical fiscal imbalance, with the national government dominating the taxing powers and therefore having, by power of the purse, enormous power over the federation, which it has exercised through its power to spend. So this, you see both a problem of executive dominance, a problem of national dominance in the federation. In this respect, I've got a little bit of an optimistic story to tell, and Renata Uwitz introduced you to it yesterday with her reference to Australian cases. In a series of very recent cases, post-2008, the High Court has begun to rein in the executive power of the Commonwealth's, at least its spending power. Okay. It first, in the Pape decision to which Renata referred, reined the federal executive in with respect to the states by limiting its spending power to matters over which it could otherwise legislate. So its power to spend couldn't be able to overcome the federal division of powers. In the follow-up decisions, with two cases called Williams No. 1 and Williams No. 2, the High Court further limits the power of the federal executive to spend so that it cannot now, as a general matter, spend except with authorising legislation. And those decisions, I think, rebalance the relationship between the executive and the legislature at the federal level. So it's taken some time, but in this respect, the court is showing a capacity to adapt a Westminster-derived executive to a federal context and at the same time to improve parliamentary oversight of its spending power. Let me turn then to the judicial power, and I think, like the United States, we have a very long, very intricate, very, for constitutional lawyers, interesting body of case law on the separation of judicial power. I think it's fair to say that it is a strong doctrine, and let me reiterate that it's operating within a context that is now in the world almost unique with respect to rights. Constitutional rights are sparse in the Australian Constitution, apart from what I think is a relatively robust protection of political expression and a guarantee of religious freedom and the non-establishment, at least, that applies to the federal government. There's little that a modern constitutionalist would recognise as a constitutional right. No criminal process rights, no jury trial rights, no equality rights. Now, in this context, the separation of the judicial power has become a site for the development of doctrines that take some of the role that in other systems you might see articulated through rights concepts. So, and there is a long history of the court using the separation of powers doctrine to reach really quite liberal rights protecting positions. So you can go back to 1951, in which the High Court of Australia, at the height of McCarthyist anti-communism, in which Australia was gripped, not quite as much as the United States, but perhaps maybe after the United States in global terms. I think the movement was strong, but nonetheless the High Court moved to protect the Australian Communist Party from dissolution in 1951 on rule of law grounds, that judgment is rightly regarded as a landmark moment in Australian constitutionalism and still a really important case in our canon. And it did happen, interestingly enough, in the same year that the United States Supreme Court upheld the Smith Act, under which the Communist Party members were prosecuted. Now, I have to skip a lot of interesting jurisprudence to say there's a more recent history as well. So courts have recently been especially active in this area, and if you look at the High Court of Australia's caseload at the moment, it is dominated by separation of judicial power cases and freedom of expression cases. Okay, so in a constitution that doesn't say very much about rights, in fact, if you look at the caseload of the court at the moment, you can see that's where the pressure is coming. So the separation of judicial power has proved effective in mitigating some of the worst excesses of Australian government. It was expanded in the 1990s to apply to state courts in a case that prevented the government of the state of New South Wales from effectively enacting what was a bill of pains and penalties. And a series of more recent cases, it winds back the worst excesses of government's attempts to regulate organised crime through an illiberal regime of control orders that applied to people by virtue of their association or supposed association with criminal gangs. So that's part of what I think is the optimistic story. The more worrying story is the nature of the failures of the separation of powers doctrine to do what we might expect a rule of law committed court would do. So having taken you to one of the glorious points in the Australian canon, I need to take you to one of our national disgraces. A case decided in 2004 called Al-Khattab, in which the High Court upheld a very illiberal reading of an immigration law that was clearly, in my view, not contemplated by anyone who drafted that law, that saw it permitting the indefinite detention of stateless persons in circumstances that I say were not clearly anticipated at the time. I just saw David Bilshitz's eyebrows nearly disappear, so I just need in national offence to say, so shocking was the decision that it was shortly after ameliorated by political action, not to excuse it, but to note that it's no longer in force. And that is justifiably regarded as a terrible low point, and a recent one. Now, if you add to that failure some cases that just seem flat out inconsistent with each other, the High Court has allowed federal judges to be co-opted into secret criminal investigations. They may, acting in their personal capacity, issue, it was back in the day when you used to tap phone lines, that kind of technology, wiretap, warrants for the secret tapping of telephone lines. However, you could compare that to cases where it is, I think, absurdly sensitive to the use of judges in contexts where the judges are clearly acting in ways that are both open and independent. It would not permit a federal judge acting in her own capacity to chair an inquiry in which, in an open way, she would deal with, it was an inquiry that required a report to be given, export evidence really, a report to be given to government. It was a way of sensitively handling a dispute within an Indigenous community that revolved around sensitive traditional knowledge belonging to women. This judge was not permitted to conduct this inquiry and write this report because the report was not binding on the minister. And this is taken to be a role that is just wholly inconsistent with the status of being a judge, which is to give non-binding advice. The judicial role requires that your decisions are binding. And so even though you're allowed to issue secret warrants, you're not allowed, in certain circumstances, to conduct independent inquiries. And you would combine this with a set of cases that undermine what I'm learning to call the fourth branch institutions. So the Australian has an independent statutory human rights commission that was given, familiar to many of you, rights to adjudicate in low-cost ways all kinds of discrimination claims. It cannot enforce those decisions by virtue of the fact that it's not a court. So, and what's more, the High Court has ruled out, in a case in 1982 called Brandis case, a system by which those decisions of the Human Rights Commission were given an enforceability by their later registration, subject to review if requested, with a court. So we have the separation of powers doctrine actually ripping out from the Human Rights Commission a really good, low-cost, effective way of dealing with human rights claims. So, failure is a part and part of constitutional adjudication, and all of us as constitutional scholars probably have lists as long as our arms of cases that we think the courts in our system decided badly. And so partly I'm just complaining in the manner of a constitutional law professor, but I want to suggest that there's something systematic going on here, and there are real reasons to have reservation about the capacity of separation of powers to do all of the work we might want it to do in the Australian constitutional context. And I think it is just too limited a framework for extensive and meaningful rights protection. Now, I want to be clear about the nature of my claim. I don't think it's a conceptual impossibility that the separation of powers doctrine could become the foundation for a full and substantive doctrine that provides significant rights protection. In the right judicial hands, things could be quite different. After all, the Supreme Court of Israel has done much more with much less. And so if Justice Aharon Barak had been the Chief Justice of Australia rather than the Chief Justice of Israel, we might have seen quite a different result. And I have been reflecting upon that delightful possibility somewhat after a conversation with Vicki Jackson yesterday. So, but frankly, with the right judicial hands, there's lots of resources in Australian constitutionalism, including the long history of rights protection at the common law, the deep rights common law jurisprudence that has been developed by judges in the other parts of the common law world from which the High Court has decisively distanced itself. the limits of the separation of powers doctrine are not, in Australia, are not conceptual limits. They're limits that reveal themselves in the context of Australia's constitutional culture, which is characterised by a determined formalism in interpretation. And that in turn, I think, is driven by some beliefs about the nature of law, as also a particular kind of democratic ideal that has a strong preference for majoritarianism. So it is not an accident, I think, that Jeremy Waldron's majoritarian democratic theories are developed by a fellow Antipodean, so much so that David Deisenhouse calls this, and I think it's not meant to be a compliment, Antipodean legal positivism. So there is, I think, a kind of culture in the Antipodes that is strongly protective of majoritarian institutions, and it's backed up by this formalist interpretation. Now, in this culture, what has happened is the concept of separation of judicial power has become untethered from any idea about what separation of powers is there to do. And it's been focused rather on a series of concepts that are sometimes treated as if they have some kind of meaning divorced from a larger set of constitutional values. So the decisions agonise and about the concept of what is the judicial power, what are the defining features of judicial power, what are the defining features of a court. Now, let me just move to make some comments on that. The formalism that characterises this jurisprudence is vastly overplayed, not only because I don't hold to the concept of law that it's committed to, I don't hold to that concept of law, but also because its tendency to suppress the values on which this judicial decisions actually and inevitably depend means that the real motivating ideology of the decisions actually achieve less scrutiny. So insofar as Antipodean legal positivism is committed to a certain kind of judicial restraint, I think is actually counterproductive. Judicial restraint is frustrated rather than improved because the motivating ideology is suppressed and not subject to much criticism. And in the Australian case, I want to suggest that the value that really explains that funny, seemingly inconsistent set of decisions to which I referred to is actually a commitment to judicial dignity. I mean, if your motivating concerns judicial dignity, that's why you're sensitive to the use of judges in non-binding contexts, but you're not sensitive to their insertion into secret investigative processes. So in the circumstances where a more defensible set of values are unavailable or just deliberately disregarded, I actually would like to claim that I think that this is maybe not the inevitable result, but it's certainly a rather predictable result that a court might end up developing a jurisprudence that reflects its own set of institutional interests and concerns. So the summary I want to give you is that we have this sort of promising but imperfect idea of separation of powers. And there's a coda I want to add here, and it's actually sort of the most depressing point of all. One possibility for Australia to address the lack of rights protection in its constitutional structure was for a long time thought to be a Human Rights Act in the model of the now endangered United Kingdom Act or the New Zealand Act. Okay. And there is one of those existing at state level in the state from which I come, Victoria. Now, in the High Court's first engagement with the Victorian Charter, what seems to have come out from a very complex decision is that the characteristic remedies provided by an act like the Human Rights Charter are constitutionally impermissible in Australia because they are thought to involve a violation of the separation of powers. So it is not permissible to give courts the power to make non-binding declarations of incompatibility. Of course, as you will recall, courts are not permitted to have non-binding roles. That's slightly oversimplifying it, but that's the essence of the decision. Even more worrying from my perspective is a line in the decision that I think has majority support, which seems to suggest that proportionality analysis is too characteristic of legislatures and therefore denied to the Australian federal courts. Now, this is breathtaking in its idiosyncrasy. After all, courts in the countries that are our closest constitutional cousins do this unproblematically, but it is the rather surprising and I think unfortunate result of this muscular but rather untethered doctrine of separation of powers. Okay. So I've come to I just would like to offer by way of conclusion and to this story that I was reflecting on the questions that David Landau raised. I mean, the question of what courts should do within constraints is just as relevant in Australia as anywhere in the global south. The constraint is what I think is taken to be the real unlikelihood of significant constitutional change to protect rights. In that circumstance, how far should the court go? I don't think it's approaching it in the right way, but it might be that it's nonetheless, in an unprincipled and erratic way, achieving something close to the right balance. I'm not sure, but just to hark back to Vicki's presentation, the Australian High Court is actually the most trusted institution in the country. So it's first, 57%, doesn't come remotely close to the military, nothing does. And I actually noticed in this polling, no one actually thought to ask Australians what they thought of their military. First is the High Court of Australia at 57%. Second is the Australian Broadcasting Commission, the national broadcaster, which warmed my heart. Parliament at 25% and political parties at 13%. So I do think the Australian High Court would risk its position if it went too far down this line. But I do think it needs a more principled way to manage its jurisprudence. I did get the time's up sign, and I'll stop there.
The University of Johannesburg. Rethink, reinvent.